Good afternoon, everyone. I'm Eric Hansen. I'm the president of Dakota Homestead Title Insurance Company and a member of the State Bar CLE Committee. Before we get started today, I want to go over a few items so you know how to participate in today's event. To start with, as before all CLE events, do you or another State Bar member or law student you know have a drug or alcohol problem or struggle with depression or anxiety? Lawyers Concern for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral and visit with LCL is strictly confidential and privileged. Call Becky Porter for more information at 605-391-5191. Becky is an LCL member, and your communications with her are likewise confidential and privileged. You can also call 988 to reach a mental health professional or the Sand Creek Employee Assistance Program at their confidential crisis hotline of 1-888-243-5744. Mental health professionals at both numbers are available 24 hours a day, 7 days a week. That information has also been copied into the chat as well. Today's presentation will last approximately 1 hour. During the presentation, please submit your questions in the chat box and typing them in the Zoom feature. I'll be monitoring that and we'll be bringing them up during the presentation or at the end. Thank you again to the South Dakota State Bar and the CLE Inc. for their support of today's program. I'd like to introduce our presenter today. Today we have Brad Hoeschen, who's the Vice President for Old Republic Title Insurance Company's North Central Region, where he oversees a team of underwriting attorneys and agency representatives that cover South Dakota, North Dakota, Minnesota, Iowa, and Wisconsin. Brad is a graduate of the Marquette University Law School as a frequent presenter on real estate, title insurance, and other topics to realtors, lenders, title companies, attorneys, and other real estate professionals throughout the Midwest. And with that quickly out of the way, Brad, I turn it over to you.
Good afternoon. Thanks very much, Eric. This is actually my 71st presentation on FinCEN, and you all put me over 1,500 people who I have spoke to about this issue, and I still feel like I'm screaming in the forest and no one hears. So I'm very thankful that the South Dakota Bar has considered how important the issue of FinCEN reporting is. Let me say before I start that in the chat I have placed 3 documents. One is the Alta FinCEN buyer collection form, and the other is the Alta FinCEN seller collection form. And then the third one is the PowerPoint presentation that I'll be giving you today. I would encourage you to download those documents and take a look at them. This is normally a 90-minute presentation, and since I only have 60, we will not be going over the buyer and seller collection forms in detail. I will just be talking with you generally about what's in those documents and how they should be gathered. We'll also talk about whether or not attorneys will want to use those forms or will want to create their own forms. So, all right, let's go ahead and kick off. Now, there are a couple of things that I want to preface our conversation with. FinCEN is the Financial Crimes Enforcement Network. It is a division of the U.S. Department of Treasury. FinCEN had in 2025 2 sets of regulations that were set to go in effect. The first was to go into effect on January the 1st of 2025, and it was a requirement that everyone who owned an interest in an entity in the United States was required to disclose the beneficial ownership information of that entity. Those regulations were very on again, off again, on again, off again. There was a court in Texas that placed a nationwide injunction on the enforcement of those regulations. Ultimately, when the Trump administration came into power, it narrowed those reporting requirements such that only foreign persons, not U.S. persons, need to make their disclosures of that beneficial ownership information. That is not what we are talking about today. And it's important to state that because I've talked with a number of folks, title insurance agents, realtors, who are like, oh, hey, I saw that FinCEN reporting went away. It did not go away. What we have is a different set of requirements that's set to take effect on December the 1st of 2025. Those requirements require title insurance agents. And by the way, I say title insurance agents because the vast majority of time it will fall to us in title insurance. But there is a waterfall we're going to go over. And part of the reason I'm glad that the South Dakota Bar Association invited me to talk today is I think there are many spots in that waterfall where attorneys are going to be obligated to report because there's not a title insurance agent involved in that transaction. So that reporting begins on December 1st of 2025, where you have a cash transaction, and we're going to define cash because it's a lot more than a bucket full of $20 bills, for residential property, and we'll define residential property because it's a lot more than a single family home, where the buyer is an entity or trust. So if those three items are present, cash transaction, residential property, the buyer is an entity or trust, then both the buyer and the seller have to report to FinCEN. I'm going to go into a lot of detail about what has to be reported, but I think that's an important place for us to start. When those three things are present, both the buyer and the seller, the transferor and transferee, are going to have to report in that transaction. Okay, so this begins on December 1st of 2025, but that is for closings on or after December 1st of 2025. That means that sometime between October 1st and October 15th, you are going to start to regularly see transactions with a closing date of December 1st or later. So we don't actually have somewhere between 75 and 90 days to get ready. What we really have is about 15 to 30 days to start preparing ourselves for the information that has to be gathered. So now that we have that little bit of background, I first want to explain to you how it is we've arrived here. That is, I think it's important for you to understand why the federal government, the U.S. Department of Treasury, through its FinCEN division, is gathering this information, because it's actually important. So starting sometime about 50 years ago, the federal government became very concerned about foreign individuals who were laundering money through the United States. At that time, most of those individuals were involved in organized crime, either in Europe or in what is the former Soviet Union and the Eastern Bloc countries. Those individuals were stealing money either through organized crime or they were stealing it directly from their governments. A lot of money at that time was stolen from public utilities in the Eastern Bloc countries. More recently, we've seen a lot of money laundering in the United States from foreign individuals involved in the illegal drug trade. So what would happen in the 1980s is a Russian oligarch would show up in the United States with a briefcase full of $5 million. And he would go to 10 or 15 different banks. And at those banks, he would open somewhere between 5 and 15 different accounts. And then the shell game would begin. He'd start transferring money from one account to another. He would move part of a deposit, and then he would open an account at a different bank and move money there. And he would engage in that shell game for somewhere between 12 and 36 months, such that at the end of that time period, it was no longer possible to trace those funds back to the original illegal transaction. They were laundered, so that he could now withdraw that $5 million plus the interest he'd gained on that money over the course of 1 to 3 years and use it for legal business enterprises in the United States. The federal government realized this was happening at a significant level, and so it passed three important pieces of legislation: the Corporate Transparency Act, the Bank Secrecy Act, and the Anti-Money Laundering Act. Those pieces of legislation require banks to report to the federal government when they see suspicious transfers of money happening in and out of the bank. So I actually have a cousin. I'm coming to you today from Minneapolis, and I have a cousin who works at Wells Fargo Bank here in Minneapolis. He works in a department at Wells Fargo that has 2,300 employees who do nothing but watch the movement of money in and out of the bank and make reports to the federal government, specifically to FinCEN, on what it believes to be suspicious transfers of funds. The result is that banks got really good at this. Wells Fargo employs 2,300 people, and other banks do this as well. All of the state and federally chartered banks, credit unions, and mortgage banks are required to do this reporting. So banks got good at it. So what happened when banks got good at tracking this reporting is that, like all good criminals, they tried to find another way to launder their money, and they turned to residential real estate. So now, instead of coming to the United States with a briefcase full of $5 million, that oligarch would go to Manhattan with a briefcase full of $25 million. But instead of looking at condos that were 25 million, he might look at condos that were 15 or 18 million dollars, and he'd pay 25 million, because he wanted to launder as much money as possible. So it didn't matter to him if he was offering more for the property than it was actually worth, because it was more important to launder a larger volume of money. He would allow that condo then to sit vacant. He wouldn't rent it out. He wouldn't use it himself at all. It would just sit. He liked a condo because he didn't have to worry about maintenance, didn't have to worry about snow plowing or lawn mowing or any of those sorts of things, right? And he'd let it sit for 2 to 4 years, and then he'd turn around and resell it. And he might list it for 25 million, but he didn't care what he got. He would sell it for 20 or 18 million dollars because 18 million clean dollars was more valuable to him than 25 million illegal dollars. So the federal government became aware that this was happening through the purchase of residential property for cash where the buyer was an entity or trust. So Andrea Gacki is the current director of FinCEN, and I find her fascinating. She was appointed by President Trump in 2016 and served the entirety of his term. And then she was reappointed by President Biden and served the entirety of his term, and has since been reappointed by President Trump and still serves as director of FinCEN. She is the longest serving director of any agency in the federal government. And the result is she has a significant amount of credibility with individuals on both sides of the aisle. So we don't have a lot of time today to talk about whether or not these regulations will actually go into effect. But I do think that Director Gacki's credibility with both Republicans and Democrats is just one piece of evidence that points to the fact that this is going to happen on December 1st. There are a couple of pieces of litigation pending. I don't think they are likely to have decisions before December 1st. And remember that decision that came out of the Supreme Court about 8 weeks ago on birthright citizenship that said district courts can no longer place nationwide injunctions. I think that's a real problem for this issue, because the district court in Texas that has this case is the same one that on the previous FinCEN issue was able to issue a nationwide injunction. He would no longer have that authority. So I think it is exceptionally likely that these regulations go forward. So in 2016, Director Gacki testified before Congress because she wanted to create geographic targeting orders. So counties throughout the country that would have to report on cash transactions for residential real estate where the buyer is an entity or trust. And she had this to say: illicit actors are exploiting the U.S. residential real estate market to launder and hide the proceeds of serious crimes with anonymity. And here's the hook: while law-abiding Americans bear the cost of inflated housing prices. Her argument, and it's correct, is that allowing individuals to bring illegal funds into the United States to drive up real estate prices is keeping everyday Americans from getting into the housing market. So they started by creating the geographic targeting orders in New York City and Miami. Since 2016, that has spread to 69 counties nationwide. The reason most of you are hearing about this for the first time is that the closest counties to you in South Dakota are either in Denver and the resort areas in Aspen and Vail, or in Chicago, Cook County. But the vast majority of the other counties are around the coasts: Pacific Coast, Atlantic Coast, and around the Gulf Coast. Now, there's one fundamental difference between the reporting that happened in the geographic targeting orders and what happens starting December 1st. And that is that in the geographic targeting order counties, there is a basement under which we do not have to report the transaction. So for instance, there are 7 counties in Texas that have to report. They are mostly Dallas, Houston, and San Antonio. But we don't have to report transactions there that are under $300,000. So that exempts us from having to report a lot of transactions. But you know what else it does? It creates a place to launder money. So instead of buying one property at 2.5 million, you buy 10 properties at $250,000, and you're laundering the same amount of money. FinCEN also realized that folks were going outside of those 69 counties so that they wouldn't get caught. One of the largest busts they've made in the last year was actually in Delaware and Pennsylvania, where a couple was laundering money obtained through the illegal drug trade through almost 50 properties in the 2 states, and there are no geographic targeting orders in Pennsylvania and Delaware. So the reason FinCEN has decided to go nationwide is, first of all, because it knew that people were going to places where there were not GTOs. I am confident there are folks who are laundering money here in Hennepin County, where I live in downtown Minneapolis. And honestly, I'm pretty sure it's happening in Pennington County as well as in Minnehaha County and Sioux Falls. The reality is that folks have simply expanded where they're purchasing property so that they don't have to report. So FinCEN, though, has good reason to want to go nationwide. And here's why. 40% of all of the reports from the geographic targeting orders correlated to bank suspicious activity reports. I want you to understand how dramatic that is. That 40% of all of our transactions were paid for with money that banks had said was being moved suspiciously. That's an astounding return on investment for FinCEN. And perhaps even more important, 7% of all of the geographic targeting order reports involved individuals who were already the suspects, the subjects of ongoing FBI investigations. That is a huge return for FinCEN. Here's my issue. Going from 69 counties to casting our net nationwide is going to reduce that number dramatically and increase the workload for title insurance companies exponentially. So while those returns are great in urban counties, we're not getting that return in Tripp and Todd County, South Dakota, or Bottineau County, North Dakota, or Carver County, Minnesota, or Pepin County, Wisconsin. The level of increased reporting is really what creates the problem for us. So let's talk then about what specifically happens on December the 1st of 2025. As I mentioned, I'm going to say this 3,000 times before we're done. We have to report on all cash transactions for residential property where the buyer is an entity or trust. So when those three components are present, then we must report. And that basement is gone. So we now have to report at $0. So let's say, for instance, that I own a property in South Dakota in my own name, and I have decided to transfer it to an LLC that Eric and I will own together. That is a reportable transaction, even though no consideration took place. Because I'm transferring to an LLC that's owned by someone other than myself, it is now a reportable transaction. I think that's where attorneys like those of you on the call today really need to be very aware, because you're going to be asked to do a lot of transactions where there isn't consideration. We'll talk about trusts, because trusts for estate planning purposes are exempt, but we want to be very careful. And in title insurance, we're going to be skeptical about whether or not the trust is really used for estate planning purposes. So let's talk about what has to be.
One
Go
thing,
ahead, Eric.
Brad, on that, just to make sure, as you cover later on, exempt doesn't just mean exempt that we don't care about things. Exempt means that there's still something that goes in. So don't tune out for just because it's an estate planning trust.
That's exactly right. There may still be other reporting that is necessary, and I'll talk about that shortly. So let's talk then about what needs to be reported. So the first thing we have to report is the basic transaction information. Now, please understand that my perspective is coming from title insurance. So from a title insurance perspective, we already have the purchase price of the property, the closing date of the transaction, and we have the legal description and the physical address of the property. So for us, that's not really going to be difficult to gather. And I think for those of you who are actively involved in real estate transactions, that's information you will already have. So we're not talking about getting anything new really from the parties. But the next category is where we start to ask them for information that we haven't had to get before. And that's where we need to report the beneficial ownership information. So here's the issue with beneficial ownership information. We must get to a human being. So if we have an LLC, owned by an LLC, owned by an LLC, owned by a trust, and the trust has human beings who are trustees and beneficiaries, that's where we report. And so by Eric's example, if that trust is really for estate planning purposes, we still have to report because it's the LLC at the top that caused us to report, right? So we have to get to a human being, and you have to keep going until you get to a human being. There are a couple of things, though, that we do want to be thoughtful about. The first is that we only have to report individuals who own more than a 25% interest, unless no one owns a 25% interest. So let's say that Eric and Alyssa and I are buying a recreational property together in South Dakota. I'm going to own 50% of that LLC. Eric will own 30%, and Alyssa will own 20%. Only Eric and I have to report because we own more than 25%. However, if there are 5 members and they all own 20%, then everyone has to report. So where no one owns more than 25%, then everyone in the transaction has to report. The other thing that's important about an LLC is that if Eric and I have decided to buy that recreational property together, but he's going to take his 50% interest in his own name, and I'm putting my 50% interest in an LLC, only I have to report. Eric does not have to report because he's taking in his own name. So those are a couple of sort of minor exceptions that are available, but they can be helpful in terms of who has to report. Now, once we decide we've found the human beings in our LLC and they have to report, here's what we need to get from them. We need to get their name. Now, you might be saying, well, that's no big deal. We know everybody's name. The fact is, in an LLC, we typically don't. The only person we care about from a title insurance perspective is the person who's authorized to sign. So if I have a member managed LLC and the member is signing those documents, I'm sorry, manager managed LLC and the manager is signing those documents, all I care about is who the manager is. I don't get the names of the other members of that LLC because their names are unimportant to me. Now we need their names. We also need their home addresses. We never ask members of an LLC for their home address. We need an address, but typically that is going to be a business address. And even if it's someone's home address, it's only one of them. It's not going to be every member of the LLC. And we need their social security number, and we also need their date of birth. Okay. And this applies to owners. It also applies to persons who exert control. So if it's a manager managed LLC, and that manager does not own an interest, the manager still needs to report. And it applies to signers. So if you have a power of attorney who's signing on behalf of an entity or trust, they also have to disclose. Or if the LLC has given a resolution to authorize someone to sign, that person needs to disclose. So it's a significant amount of information. And if any of those members is not a US citizen, we also need their identifying number from their country of origin. That will usually be a passport number, but it could be some other identifying number that that country issues. And if they are present in the United States, we need the visa number that allows them to be present in the United States. So we're gathering a significant amount of non-public data. And whether it's an attorney or the title insurance agent, we are obligated to retain that data for 5 years, which means that we now have an even greater cybersecurity risk than we've had before because we're gathering information that we haven't had to gather before. So that's how we handle LLCs. Partnerships are going to be handled almost identically. That is, general partners always have to report, and any general partner who owns more than a 25% interest will have to report unless no one owns a 25% interest. Generally, limited partners will not have to report because they are not going to own a 25% interest. But if for some reason a limited partner does, that limited partner is going to have to report. So we've got LLCs, we've got partnerships. The next is corporations. So corporations don't have owners, right? They have shareholders. That means somebody has to report. FinCEN has determined that the report needs to come from the executive leadership. So president, CEO, sometimes that's one person, sometimes it's two, treasurer and CFO, okay? And the entire board of directors. And so for private corporations, they often have 9, 11, or 13 members. So you're gathering this information from a lot of people. And that applies to for-profit corporations and not-for-profit corporations. So if we have the Boys and Girls Club of Minnehaha County that is doing a $500,000 fundraiser to purchase a residential property that they're going to use for transitional living, or for life skills training, for instance, when they purchase that property using the money they got from the fundraiser, they are purchasing with cash. And so now every member of the board of directors, in addition to the executive leadership team, is going to have to report. So, in the theme of no good deed goes unpunished, serving on the board of directors of the Minnehaha County Boys and Girls Club could require you to report this information to FinCEN. So, those are our entities generally. Then we also have trusts. Now, as I mentioned, trusts for estate planning purposes generally do not have to report. However, passive trusts are required to report. I think there are attorneys who draft passive trusts for estate planning purposes. So if we have a passive trust, which means that the trustee does not have the authority to sell without the consent of the beneficiary, that trust has to report. When we have a trust that has to report, and by the way, this is important to FinCEN because beneficiaries is where the oligarchs were burying themselves. They're like, oh, well, they'll never find me if I list myself as the beneficiary. But they would draft a passive trust that would give all the power and authority to that beneficiary. So the reality is that the beneficiary was essentially acting as the trustee. So that's why FinCEN is particularly concerned. So when we report for trusts, we have to report for the trustees, just the current trustees, so you don't need to worry about secondary trustees, and all of the beneficiaries. There are a number of problems with reporting for beneficiaries. One is there are a lot of minors who are beneficiaries. So now we're gathering social security numbers and dates of birth for children, and we have to retain that information for 5 years. Additionally, if when someone creates a trust, they often don't tell the beneficiaries who they are, right? If mom and dad have left one of their kids out, they're not going to advertise. We've created a trust, but only two of you are beneficiaries. The third one is not. So now we have to get information from people who don't know they are beneficiaries of trusts, unless mom and dad happen to have all of the necessary information to disclose. One of my biggest concerns, though, is that if a beneficiary is a minor who is not a US citizen, there are many countries that do not issue identifying numbers at birth like we do social security numbers in the United States. So that child may not get an identifying number until they get a passport or a driver's license or some other document, which they may not get until they're 5 or 10 or 15 or 20 years old, right? When we do not have one of the reportable pieces of information, we can't submit the report. We must submit a suspicious activity report. So suddenly we're telling the FBI that this transaction is suspicious solely because we have a minor foreign child who doesn't have an identifying number. To me, that's problematic, but that is what the rules require. And I do want to give you one very personal example about disclosures on a trust. So, I have a trust that I own my condominium in downtown Minneapolis. And so, if I'm the trustee, I am the trustee. If I have to disclose, I have to disclose my name, home address, social security number, and date of birth. Let me tell you, I'm a realist. I know that you can go on the dark web and pay somebody $100 to get that information. I've been using my social security number as a student ID number in college and in law school. I use it to get car loans. I know that number is out there. You can get it if you really want to and you're willing to pay for it. But my children are the beneficiaries of my trust. And so if I have to disclose, I have to disclose my children's home address. In this case, even though they're 23 and 25, their permanent address is mine, their names, their social security numbers, and their date of birth. But the reason their home address is mine is because they both live outside the United States. They both live in London. One is there on a work visa and the other is there on a student visa. So if I sell my condo for cash to an entity or trust, I also have to disclose my children's US passport numbers and their visa numbers that allow them to live in the United Kingdom. That is information we protect, right? You can't go on the dark web and purchase my kids' passport numbers or their visa numbers that allow them to live in the UK. And yet now I have to give it to a title insurance agency who's going to turn it over to FinCEN. That's a lot of non-public information. So in addition to reporting that information, we also have to report the payment information on the transaction. So Eric mentioned that I manage my company's operations in a number of states, including Wisconsin. In the southwest corner of Wisconsin, we have a lot of Amish, not unlike the Hutterite communities that you have in north central South Dakota. So a couple times a month, an Amish couple will roll up in a buggy with a beautifully handcrafted Amish crate full of $100 bills. and they will pay cash for real estate. And so we report that we have received cash. But many times we don't receive cash. Instead, we receive wires. We now have to report the bank from where that wire came, the routing number of that bank, the account number from where the money came, and the holder of that account. And we're going to ask for that information on the buyer collection form. But one of my big concerns is we're allowed to rely on the information in the buyer collection form unless we know it to be wrong. We're going to ask that those forms be given to us 10 to 14 days before closing. There are lots of times when people change the accounts they're going to send money from before closing, and they're not going to tell us, not because they're lying or trying to hide it from us, but because they forget, because they didn't realize that they filled out that form. It's now our obligation to compare where we received the money from as to where they told us we were getting the money. We are obligated to report where the money came from, not where they told us it was coming from. This also applies to cashier's checks. And cashier's checks are money that comes from the bank. That's not what we have to report. We have to report the money that funded the cashier's check. So we need to find out from the buyer where it is they took that money. What was the bank, account number, routing number, and who was the holder of that account. And we are obligated to report funds that come at closing, but also funds paid outside of closing. So earnest money payments that are made to the realtor, which the realtor holds and then keeps. They never give it to us because they keep it to offset their real estate commission. We still need to find out where that money came from. Similarly, if there's an agreement in the purchase agreement that says the seller will pay the buyer $2,000 outside of closing for well repairs, we have to report that money. So there's a lot of following the money here. And I will tell you one of the reasons this annoys me more than many of the other things. You know who's responsible for the federal wire service? The U.S. Department of Treasury, which also controls FinCEN. They already have the information they're asking us to provide, but they want us to provide it in a format that's easier for them, even though they already have that information. So who has to report? We're going to start with the settlement agent, but we'll get to that waterfall in just a few minutes. There will be an electronic form that FinCEN will require us to fill out. That's going to be a portal, so we're not uploading PDFs. The GTOs are uploading PDFs right now. That's because there weren't nearly as many reports. We're going to be filing millions of reports. So FinCEN doesn't want to receive PDFs. We're going to be using a portal. The report is required to be filed 30 days after closing. Now, you might look at that and think, oh, well, that means I don't need to get this information until after closing, right? How cooperative are buyers and sellers after closing? I like to say that the seller is on the first plane to Vegas to spend all of their money on gambling. We're never going to see them again, and they're not going to cooperate with us. So it's important, I think, from a title insurance perspective, that we're going to gather this information prior to closing. So as attorneys who work on transactions, you should understand that we are going to delay closing. We're not going to close if we don't have this information from the parties at the time of closing. And here's why that's a problem. How often does an individual buyer under a purchase agreement decide 2 days before closing they want to put the property in an LLC? All the time. Or how often does someone come to closing and say to us, so look, here's a deed to our trust that we want you to record after closing. And now we don't have the ability to figure out whether or not it's for estate planning purposes or whether or not it needs to report. So we may need to stop the closing until we can make those determinations. So I don't want people to rely on, oh, well, there's 30 days after closing. That's when you can get the information. We won't be doing that. We'll be requiring it prior to closing. And we would certainly encourage attorneys to do the same when they're handling transactions that don't involve a title insurance agent. So FinCEN has FinCEN has released a draft of the portal that will allow us to submit this information. They released that draft in November of last year. The comment period was supposed to be 60 days, but it was actually extended to July the 8th of 2025 because everybody had a lot to say. FinCEN then was supposed to have 30 days to produce a final form with the Office of Management and Budget. We knew on July the 8th that they were not going to have it done in 30 days. It is still not done. I talked with FinCEN on July the 16th and said, so what, August 1st? They said, we don't know. It is my expectation that we will have this sometime in October, right? Sometime probably around the 15th of October. I think if they give it to us much later than that, the argument that it needs to be delayed, it gets pretty strong. For those of you, though, who think you're going to have to report, you can currently register with FinCEN to be the reporting person for your company or your entity. We would encourage you to explore that sooner than later. The draft form had 111 fields, and FinCEN estimates that approximately 60% of those are going to be mandatory. FinCEN has estimated that it's going to take somewhere between 2 and 2.5 hours to fill this out for somebody who's new, and about 45 minutes for someone who's experienced. FinCEN has been testing the form, and its own people have a 10% error rate on testing the form. So we know that title insurance is going to have a much higher error rate when we get started. Now, let me say this. There are software companies who are working on programs that will allow them to file this for us. We've heard that those fees are going to be somewhere between $150 and $250 per transaction. The title agent is also going to charge a fee to collect this information. I think that'll be similar. So I think we are looking at a total fee of somewhere between $300 and $500 per transaction. So parties need to know that going in. You know, one of my concerns is that right now the standard purchase agreement in South Dakota does not require the seller to participate in FinCEN disclosure or potentially pay any FinCEN fees. So it is my recommendation that realtors and brokers consider an addendum that would require the seller to participate. Wisconsin has already adopted an addendum that requires disclosure of FinCEN information. California also has an addendum, but many states will not be ready by December 1st. Minnesota is one of those. I am confident South Dakota will not have a standard form ready by December 1st. So we would encourage those of you who do drafting of the contracts to create some sort of addendum, because here's my concern. The seller has to report also. There are sellers in South Dakota who intentionally came there to launder money and avoid reporting in the GTOs. So if I'm that seller, I sure as hell am not going to want to have to report now. I swore, dang it. I told myself I wasn't swearing because you were recording this and I just swore. Oh, well. But we're not going to want to report if I'm a seller who came to South Dakota to avoid reporting, and now you're going to ask me to report on the way out when I know I'm laundering money. So I think we've reached a point where cash is no longer going to be king, because there are going to be some sellers who are not going to want to accept cash transactions. So let's talk about what cash is, because it's a lot more than that handcrafted Hutterite crate full of $100 bills. So first of all, cash is where there is no outside funding, right? So where we just get wires in from someone who's paying cash, that is considered a cash transaction. Similarly, if someone does a contract for deed in South Dakota, that is cash because there's no mortgage being placed on the property. If someone does a home equity line of credit on their primary residence and uses that money to purchase a second residence, that is cash because there's no loan going on the primary residence. But here's really the best way to think of it. Cash is any funding coming from an entity that does not have an anti-money laundering reporting requirement. So if it is not a state or federally chartered bank, state or federally chartered credit union, or state or federally chartered mortgage bank, it does not have an anti-money laundering reporting requirement. So hard money lenders, typically out of California, who work with flippers or developers buying vacant lots, that is going to be considered cash. An important one for us in South Dakota, Farm Credit Service agencies are not anti-money laundering reporters, which means that any loan from a Farm Credit Service agency is considered cash, and therefore that could potentially be a reportable transaction. We in title insurance will be asking the lenders, do you have an anti-money laundering reporting requirement? If the answer is, what's that? Well, then we know that they don't know what an anti-money laundering reporter is. But they have a four-digit number because there are fewer than 10,000 of them nationwide. So we will be keeping track of who has an anti-money laundering reporting requirement so that we know whether or not we are going to have to report. So FinCEN estimates that this is going to affect 28% of all transactions nationwide. I tell you, in many of my states, I think that number is a little high. But in a state like South Dakota, where we have a lot of agricultural land, and agricultural land is considered residential, I do think it's possible that you could see reporting as high as 28%. So it's important to be thoughtful about that when you're sort of planning how to handle this going forward. So let's talk about what residential real estate is. Residential real estate is a 1 to 4 family occupancy, so it doesn't have to be owner occupied. It can be rental property. That's an easy one. It's what we know residential to be. It's also condominiums. That's easy, right? We know that residential condominiums are for residential use. Where it starts to get more complicated is mixed use properties. So I gave this speech a few weeks ago in Menominee, Wisconsin, and I don't know if any of you have ever been there, but you cannot spit in downtown Menominee without hitting a bar that has 2 apartments upstairs, right? That is mixed use property, and that's considered residential for purposes of reporting. I was visiting with an agent of ours in Miller, South Dakota, and she has a building like this. Her office is downstairs, and the other half of the downstairs is the State Farm agent in town. And upstairs, there are 3 apartments, but they're not rented out. It doesn't matter if the apartments are vacant or not. If they are zoned for a residential use or permitted for a residential use, then they are residential. That means that title insurance agents are going to be looking at listings for properties and determining, does this building have any residential use in it? Certainly, attorneys who are doing these sorts of private transactions need to make sure that if there is a residential use, they're figuring out how the reporting is going to be done. But residential also includes vacant or unimproved land that is zoned or permitted for residential use. So this is primarily going to be lots and subdivisions, right? Now, I will tell you that one of my concerns about FinCEN's regulations is they say that we have to report vacant land where the owner intends to build a residence on it. So with vacant lots, I'm quite comfortable that they intend to. The timing doesn't matter. But what concerns me is that FinCEN won't tell us what intent means. Is it 6 months? Is it 12? Is it 12 months? Is it 2 years? Is it 10 years? What is it? Because the other land that is covered is land where you are permitted to build a residential property. That's agricultural lands. I understand there's some ag land that has restrictions on it. Maybe it has an easement for cropland preservation or forest land preservation, but in general, you're allowed to build a homestead on ag land in South Dakota. And so because they won't tell us what the intention is it 2 years or 5 years, I think we have to default to the fact that the sale of agricultural land is residential, and we're going to have to report that. The last one is co-op property. Eric, I'm not aware of any co-ops in South Dakota. Are you aware of co-op property in South Dakota?
No, we really don't have any housing cooperatives that go with it. We may have some housing partnerships in local areas that develop things, but they sell those into individuals that go with. Um, the only question would just be is if they also provide renters assistance potentially too when they buy. It's an entity, but that's I think going to be what we have no matter what because it's an entity purchasing. So when like a development foundation purchases land, they're already having to report. So I don't see a cooperative housing market. I will say, Brad, I think that on the ag one, our building eligibilities, we have
Right.
advertised a lot that go with our ag transactions with the building eligibility. That's a clear indication in my mind that that's a residential one for reporting, even if it's not used at any point in the near future for it.
So I do just want to say quickly about co-ops. If any of you work over the border in Minnesota, they are mostly here in the Minneapolis area. However, we're seeing an increasing number of retirement communities being built as co-ops instead of as condominiums. The issue is that there's no title insurance for a co-op because co-ops are not real estate. They are personal property. So it's less likely that a title insurance agent would be involved in a co-op transaction, which means attorneys need to be thoughtful about the potential to have to report those transactions. So in terms of who is covered, I have attached for you, as I mentioned, the buyer disclosure form, buyer collection form and seller collection form. Let me say this. These were drafted by the American Land Title Association. They are not mandatory. It is my expectation that title insurance agents will always use the Alta collection form. There's no reason for us to reinvent the wheel. The form is available for you as attorneys to use them if you want. There's no fee currently to use that form. So we would encourage you to at least look at it and make sure if you want to draft your own that you're covering the same items that are contained in those collection form. Somebody said they can't see the attachments. If you scroll all the way to the top of the chat, there are 3 documents attached there. If you still can't see them, we'll figure out how to get them to you after the
It will be
presentation.
posted on the State Bar website under the CLE committee page as well. On there, there'll be all the presentation, the handouts, and the PDF version that went along with it. And you'll be able to see the video.
Excellent. So there are a couple of things that I want to point out in that collection form. The collection form can be filled out by individuals other than the members of the LLC. One of the boxes is for the attorney. So an attorney can fill it out, so can a realtor. I would caution you to make sure you read the certification on the last page, because the certification provides indemnification to whoever is doing the reporter that if the person who certifies gave us incorrect information, we have the right to collect all of our damages from you. As an attorney myself, I would be very reluctant to sign that on behalf of my clients. And let me just say this. I think the other people who are going to be reluctant are other members of an LLC. So if I own an LLC with Eric, I like him. I trust him reasonably well. That is, I trust that when he buys me a drink, it won't have a roofie in it, right? But do I trust him to give me the correct social security number? I think I would rather he fill out his own form. So part of my concern is that instead of us getting 1 9-page form, we're going to get 2 or 4 9-page forms. Or if we have a corporation with 9 members of the board of directors, we might get 9 different 9-page forms. So the gathering of the information can become pretty significant to us. There are some exemptions from filing that I would encourage you to look at in those in the regulations. They're very narrow. That is, they include insurance companies like mine. They're generally highly regulated companies, banks, securities companies, municipalities, those sorts of things. But there are some exemptions listed there. There is a question as to whether or not there's an exemption for government entities. There is an exemption for government entities. Because they're already highly regulated, they would have to report the information. Okay, there are some transfers that are exempt. I'm going to talk about those. Here's what I want you to think about from the jump. These exemptions are exceptionally narrow. We should not be viewing them as a broad exemption from reporting. So the first is any transfer that's solely related to an easement. So a grant, transfer, or revocation of an easement where no real property is being transferred, that is exempt. We do not have to report easement-only transfers. Then we have a transfer resulting from the death of an owner of residential real property where they designated prior to their death who is getting the property. So in South Dakota, you have a Todd. If we have a transfer on death deed that designates an entity or a trust to receive the property, they do not have to report because that designation was made prior to death. The same is true if we have a will where a transfer is made from the probate to the entity or trust designated in the will. And the same is true if we have a trust that is granting the property to an entity or a trust going forward. But if, for instance, I suspect you've seen this, but this is one I see a lot, where someone in their will gives their property to the Humane Society, and the Humane Society decides it does not want that property, then if the probate sells to a third party, the designation didn't happen, it wasn't transferred to the Humane Society, they sell to a third party, that is a reportable transaction. If an entity receives the property by Todd and then they turn around and sell it, that is a reportable transaction. The same is true of a trust. So the only exemption is the narrow time when an entity or trust receives property as a result of a designation prior to death. The third one is probably the one I like the least. And the reason I like this one the least is in my 25 years of law practice, I have never seen this happen. So this is a transfer incident to divorce or dissolution of marriage. And by the way, I know that FinCEN is revising its definition on this. It is a transfer incident to divorce or dissolution of marriage where the spouse who receives the property decides to take it in an entity or trust. So wife is granted the property at the time of divorce, but she, for whatever reason, decides she wants to take it in an LLC. That is not a reportable transaction. But if at the time of divorce, husband and wife are transferring the property to an entity or trust, that is still a reportable transaction. So it's just that very narrow exception. The fourth one I'm going to cover very quickly because attorneys, I suspect, understand this better than folks in title insurance. The transfer to a bankruptcy estate, which, as you know, happens as a matter of law. There is no deed. When you file bankruptcy as a matter of law, the bankruptcy court owns the property. That is not reportable because it never goes of record. But when the bankruptcy estate transfers the property out at the end of the bankruptcy, that is a reportable transaction. Okay? So it's just the narrow thing that happens at the time of reporting. The fifth one here, if there's a loophole left, this is the loophole. So it is a transfer for which there is no reporting person. All right. So let's take my son, Isaac. He doesn't work at a title insurance company and he's not a lawyer. So he wouldn't inherently have an obligation to report. So let's say Isaac owned a parcel of property and he decided that he wanted to transfer it to an LLC that he owns with his brother. He could go online, print out a quitclaim deed. He could put in the legal description himself. And then he could get it notarized at the bank and then walk down to the recorder's office and record this himself. If that happens, there's no one in the transaction whose job it is to report. If there's a loophole, it's that the oligarch is going to go directly to an individual and offer to purchase the property from them for cash, do the transaction themselves so that there's no reporting. I think that's not likely to happen on a grand scale, but if there's a loophole, this is the loophole. Here's my problem with that. It encourages people to do home cooked deeds. And if you asked us in title insurance if we could wave a wand and make one thing go away, it would be individuals drafting their own deeds because they screw them up. They mess up the legal description, they get a name wrong, they put the grantee and the grantor in the wrong place. They do all sorts of silly things. And then when they actually go to sell that property, we in title insurance have to fix it. And now it's a reportable transaction. So I don't like this exception, but I understand why it's there. And then the last one is just for the QI in a 1031 exchange. So 1031 exchanges are still reportable where there's no loan between the buyer and the seller, but the qualified intermediary does not have to report just for receiving the money or for receiving the property. All right, who has to report? So I talked about how there was a waterfall, and this is the waterfall, and this is where I think attorneys should be concerned. Eric, do we need to answer that question before I move on, or no? Sorry, you're muted. Should I just keep going? Okay, I'll keep going. So the waterfall. The waterfall tells us who has to report. So the first choice, and what's going to happen most often, is the person who is listed as the settlement agent on the settlement statement. So that's our closer, right? The closer is going to be responsible for doing the reporting. Now, to be clear, closers are not going to be doing this reporting. Either title agents will be contracting this out or they'll have someone in their office whose job it is to be doing this reporting. But from a regulatory perspective, that responsibility is going to fall on the closer. There are times, though, where the lender closes their own loan, but they still have the title insurance agent draft for them the settlement statement. So then we are still responsible because we drafted the settlement statement. Now we get to issues that I think are going to address attorneys the most. So attorneys do a lot of transactions where there isn't really a closing, right? Where they're handling a private transaction. So grandma and grandpa are transferring property to their grandchildren, agricultural property or the family homestead, right? So now it's the person who records the deed for recordation. I just saw the comment that said retirement is now closer. This is about the point in the speech every time I give it, that someone either quits or tries to find a loophole. So I'm not surprised to see that comment that retirement is closer. So the person who records the deed for recordation. So if we have an individual who has come to an attorney to handle a transaction for them, right? And the attorney takes the deed and has it recorded from someone in the attorney's office. The attorney is responsible for reporting. Now, let me tell you, from a title insurance perspective, this is going to end courtesy recording. So there were lots of times when we would handle a refinance and somebody would come into the closing and say, hey, I've decided I want to transfer this to my LLC. Here's a deed and the recording fee. Will you record this after you record the mortgage? We would do that all the time. We can't do that anymore because now that transfer may be reportable. We're not interested in taking on that responsibility, and we would have to charge a substantial fee if we were going to take on that responsibility. So I think courtesy recording goes away, but I do think it's an issue that attorneys are going to have to deal with. If there's no one who does the recording, then it's the person that issues the owner's policy of title insurance. So look, that's my company. And the problem with that requirement is that we never know within 30 days of closing when our agent has issued a policy. They're required to tell us within 60 days. Many of us don't tell us for 90 or 120 days, but we never know within 30 days. So the title insurance agent is going to be involved in trying to figure out how this can be answered. The fifth choice is the person that dispenses the greatest amount of funds. So I think this impacts attorneys who handle private transactions between relatives or friends, right? You take the money into your trust account and then you pay out the expenses. That has the ability to trigger reporting on behalf of the attorney and the law firm. The sixth choice is the person who does the title examination. I don't like this one because the title examiner never knows if that transaction closes. And then the last one is the person that prepares the deed. So this impacts lawyers. And I think this specifically impacts trust and estate lawyers who spend most of their time and energy thinking about complicated LLC documents or complicated trust documents. And the drafting of the deed is a throwaway. It's done by a paralegal, and then the deed gets recorded. But just by virtue of drafting that deed, it puts the attorney in line of reporting. I will tell you that title insurance agents are not going to do courtesy drafting anymore. There are times when regular customers would come to us and say, hey, I want to transfer this to my LLC. Will you draft a deed? We used to do that, and we won't anymore because the risk is too high. All right, so we arrive at December 1st, and we decide we will not comply. FinCEN has a number of penalties that it can impose. The first is there is criminal liability of up to $250,000 and 5 years in prison per transaction. I do not look good in orange. So we are going to be complying, right? We're going to make sure that we comply. I will tell you that FinCEN has had this ability since 2016 when it created the geographic targeting orders, and it appears to be holding criminal liability for individuals who are conspiring with someone laundering money to hide those funds. For instance, there was an attorney in New York who was helping his Russian client hide the purchase of a property in the Hamptons. That is, the attorney took title himself instead of the client, and FinCEN sought criminal penalties in that case. But even where there's not a criminal penalty, civil liability is the greater of the amount involved in the transaction, up to $100,000, or $25,000 per transaction per day the violation continues. So if your law firm did 4 closings on December 1st, didn't realize on December 2nd that the filing hadn't been done, and so you don't do the filing until December 5th, you have $25,000 per transaction. That's $100,000 for the 4 transactions times 5 days late. That's $500,000 in fines. Now, since 2015, FinCEN has not generally instituted the highest and largest amount of fine. Most of their fines have been between $5,000 and $100,000. But still, even a $5,000 fine is substantial in a real estate practice where we're doing deeds or transactions for $1,000 or $1,500 or even $5,000. There is no safe harbor for good faith attempts to file. That means that if you have 4 members of an LLC and only 3 of them give you the information, you have to file a suspicious activity report. FinCEN will not accept an incomplete report, even if it's because someone wouldn't file. And then finally, FinCEN has determined that the attorney-client privilege does not apply. I have to tell you, I have a real problem with that. I don't think FinCEN can make us waive the attorney-client privilege, but someone is going to have to challenge that finding, and it's not going to be me. So I think until that's challenged, we have to assume that we can't claim that the attorney-client privilege keeps us from filing this information. So that's what I have for you. It does look like we lost Eric. I just
I'm
want to look
back.
at the. Oh, okay, great. So I just want to look at the questions. Is there a reporting requirement if someone transfers their own residential property into a trust for estate planning purposes? No, as long as we're sure that it's for estate planning purposes. That's my primary concern. The title insurance agent is going to be looking at the trust to figure out if it really is for estate planning purposes or if it's a passive trust. So we just want you to be aware that we will be looking at that because we're going to be concerned about it. For exemptions for reporting, the list in the regulations focused on parties that are already highly regulated. I think that the buyer is already reporting the same information and likely more regulatory bodies like publicly traded companies and the SEC insurance. Most business entities and trusts are not going to fit. That's 100% true. That list of exemption is highly regulated companies, and we will not see those terribly often. If you'd like to unmute and ask a question real quick, I just went 1 minute over, but if there are any other questions, I'll take those real quickly. Alyssa, I think it's yours.